रेडी। जो पहले वाला कंटेंट बोला था वो 3P उसका था, क्रिमिनल मैटर का 9 नंबर था। अभी मैं जो डिक्टेट कर रहा हूँ वो 3P लीगल में से डिक्टेट कर रहा हूँ। और ये वर्ड्स आप एक बार देख लेंगे। ये पहला वर्ड क्या है? एड वोलरम, पाल्मा मैटर, साइन डाई, स्टेटस को, सब जुडिस, पर्सोना ग्रांटा, पर्सोना नॉन ग्रांटा। और जो इनके मीनिंग है, जो फर्स्ट वर्ड आपको लिखा हुआ है एड वोलरम, एड वोलरम मतलब क्या होता है? अकॉर्डिंग टू वैल्यू। दूसरा है आल्मा मैटर, अप्लाइड बाय स्टूडेंट टू द यूनिवर्सिटी, फॉर देयर यूनिवर्सिटी। अपनी यूनिवर्सिटी के लिए जब अप्लाई करते हैं इसको बोलते हैं एल्मा मैटर। साइन डाई, ए पर्सोना नॉन ग्रांटा, ए पर्सन नॉट एक्सेप्टेबल। सब जुडिस, सब जुडिस अंडर कंसिडरेशन, जो अभी फाइनल नहीं हुआ है। लिखो 3P लीगल से लिखेंगे। स्टार्ट इट। Challenge in this appeal is to the judgment rendered by a division bench of the Odisha High Court holding that the policy decision taken by the state in the matter of allotment of quarters on rotation basis was illegal. Adumbrated in brief the factual background as projected by the appellants is as follows. An executive order was passed by the Deputy Inspector General of Police in furtherance to a policy decision that quarters were to be allotted to all the Odisha state armed police personnel for a minimum period of 3 years. This order was passed keeping in view the dearth of family accommodation. It was also done with a view to ensure that every police personnel enjoyed the facility of rent-free accommodation. The practice had continued uninterruptedly for a long time. The system was developed to ensure that the employees are provided with quarters for a given period, and after completion of that period, they are required to vacate the quarters. This would enable other employees who are deprived of quarters to get quarters so vacated. Questioning legality of the orders, the respondents filed an original application number 758 of 1989 before the Odisha Administrative Tribunal. Challenge in the application was to the system of allotment of quarters by rotation. The tribunal dismissed the application, holding that it had no jurisdiction to consider the matter, as the same was a dispute related to allotment of quarters, which is not covered by the special accommodation rules. It was held that since quarters were allotted by contractual allotments, the special accommodation rules do not apply. After dismissal of the appeal, the applicants filed the writ petition number 3193 of 1992. In the writ petition, the High Court, by its impugned judgment, held that the policy decision of allotment of quarters on rotational basis was contrary to and inconsistent with justness and fair play. In support of the appeal, learned counsel for the appellants submitted that the approach of the High Court is clearly erroneous. It failed to notice that the policy decision of the government is not to be interfered with. However, no justifiable reason to question the policy decision was given. There is no appearance on behalf of the respondents. Operation of the impugned judgment was stayed by this court by order dated 8th May 1997. While exercising the power of judicial review of administrative action, the court is not the appellate authority and the Constitution does not permit the court to direct or advise the executive in matter of policy or to summarize any matter which under the Constitution lies within the sphere of the legislature or the executive, provided these authorities do not transgress their constitutional limits or statutory power. The scope of judicial inquiry is confined to the question whether the decision taken by the government is against any statutory provisions or not. Thus, even if the decision does not appear to be agreeable to the court, it cannot interfere. The policy decision must be left to the government, as it alone can decide which policy should be adopted after considering all the points from different angles. In matter of policy decisions or exercise of discretion, so long as the infringement if fundamental right is not shown, courts will have no occasion to interfere with them. In assessing the propriety of a decision, even if a second view is possible, court cannot interfere. What is the best is not always discernible. The wisdom of any choice may be disputed or condemned. Mere errors of government are not subject to our judicial review. 594 वर्ड डिक्टेट किए गए हैं, 80 की स्पीड है, 3P लीगल का 9 नंबर है। जीडीबी से लिखेंगे।